Welcome back. This is The Firm. SEBI's powers to settle an offence or a default or a violation were always a bit suspect. There are no explicit settlement or consent directions in the SEBI Act. So SEBI relied upon Section 15T2, which gave it these powers implicitly. Last year, a PIL filed in the Delhi High Court challenged SEBI's powers to settle a violation. But before the case could reach a conclusion, an ordinance, actually two of them, amended the SEBI Act and under new Section 15JB gave SEBI explicit powers to settle or consent retroactively from 2007, thereby legitimizing all consent orders passed to date. Now, this amendment to settle administrative and civil proceedings calls for regulations, and hence SEBI has issued what I'm calling draft consent regulations because the formal title is just too long. So far, so good, until you discover that the draft regulations deviate from the current position SEBI holds on consent proceedings. Now, since SEBI itself has requested feedback, join me in welcoming Shardul Shroff of Amarchand Mangaldas and Sridhar Gorti of Tri-Legal. Gentlemen, to both of you, a very warm welcome. First question to you, Shardul, and that's the offences or violations or defaults that the draft regulation covers. It says very clearly in its title that this is the settlement of administrative and civil proceedings regulations for 2013, which is a departure from what the 2007 circular of SEBI said, which also allowed for the settlement of criminal offences. This is a big shift, right?
Yes, it is a big shift, and I think a correct shift, for the reason that if you see the terms of Section 15JB, and you look at sections 24 and 24 capital A, which have been on the statute book since 2002, there is a separate procedure which was already contemplated by the Act, that if you have to compound an offence, then the procedure is before either a court or the SEBI appellate tribunal.
Okay.
That was part of section 24A. So when they had in 2007 and then in 2012 gone ahead with these guidelines, it could have been argued that if the power is contained in the Act in section 24A, how did you assume this under 15T2 at all in a guideline or in a consent procedure?
Any offence which had a fine as well as imprisonment possibly is not something that should have been the subject matter of consent orders.
In fact, Menka, I'll just add one more, that in the 2007 formulation, they had carefully said that offences are only those which are technically offences but which are yet to be filed. I think they've even removed that issue now, because if at all that was the problem. And it's a grey area to say that if it is not lodged as a complaint, is it an offence? So technically it could have been argued that, look, we could settle something which had not resulted in a complaint, and therefore it was like an administrative process, because it didn't result in actually an offence being lodged. But I think they've just got away from that argument now by restricting it to the expression defaults, which is purely civil in nature.
All right. So then let me come to one thing that I thought was core to this shift in position between the circulars of 2007 and 2012, specifically 2012, and these draft regulations. In 2012, SEBI made a departure from its previous position and decided to list a negative list of, I used to call them offences, now I will call them defaults or violations, and said that in the case of such violations or defaults, SEBI shall not settle. Yes, they gave themselves an out at the end, where, you know, I suppose they said that in the rarest of rare cases, the high-powered advisory committee or the panel of whole-time members might consider a settlement. But it was very clear, shall not settle. The wording in the draft regulations has shifted to may not settle, and then they've gone on in a part of that section, in the subsection, to say, and they may settle any of these violations on the negative list if it's in the interest of investors in the capital markets, etc. Do you read this as a big fundamental shift in what was a blacklist last year and has now become a grey list this year?
Yeah, from a legal interpretation standpoint, it's clearly two different things. When you use the word shall not, then clearly that word shall ordinarily implies an imperative.
Right.
And so while it is certainly true that in certain facts and certain circumstances courts have held that shall could mean may, etc. But the fact is that when you use the word shall, the first and obvious interpretation is that it is a mandatory provision. So when you are making an exception to a mandatory provision, the standard of justification you will have to provide is significantly higher. But when you say may not, now this is actually more like confirming or conferring an authority or conferring a power to a particular statutory body. So what this does is that it's sort of allowing SEBI to disallow consent terms on this negative list. So it's clearly a different, now if you can imagine in this context, the level of justification that they would have to provide, at least from a legal interpretation standpoint, goes down.
I totally agree with the way Sridhar has put it forth, and my view is synchronous with his view. I just wanted to point out two more, issues which I feel are troublesome in Regulation 5.
Okay.
They have introduced 5.3, which actually says that an application involving alleged defaults may be rejected by the board without examination by the internal committee or the high-powered committee. So what has happened in 5.3 is that they have subsumed, the board has taken away what was in the domain of the high-powered committee and or the internal committee. Now, I find that this is absent. This, when you look at Regulation 10 or when you look at Regulation 11 or the whole sequence of 10 to 13, the scheme seems to indicate that when an application comes, you have to send it to the high-powered committee, and the process has to go through the committees which have been constituted. It was not this discretionary, and that is why I again sort of bring focus to draft Regulation 6, and when you look at it with Regulation 9, they have prescribed factors, but they are trying to reserve to themselves the ability to issue guidelines in addition to the factors which are stated in 9. I think that's wholly wrong, because if you have enunciated Regulation 30 and you have enunciated 115 your JB, then the law states that you have to put it in a regulation. To superimpose a guideline and therefore to give yourself the ability to change it at will is wrong law.
I'm glad you use the word discretionary, Shardul, because all of it has become discretionary. Actually, the moment they say we may not settle, and then they've gone on to say, but we may settle if it's in the interest of investors or the capital markets, you made all of this discretionary. So if you have two people with insider trading charges against them, you may choose to settle one and you may choose not to settle the other one, and you're basically sending out a very confused signal, out there in terms of what is settlable and what is not settlable.
And in fact, I would add that there's a pernicious element to this. If you look at the schedule, you have to waive your right of appeal. So if there are two applicants, as you rightly said, one whom they give discretion to you, to that person, and one they don't, then, and you have waived your right of appeal and you don't have any procedure of going upstream, because that's a part of the application itself, you are then inviting a writ action because it's discriminatory. And the discretion will therefore have to follow precedent. It will have to follow, and therefore there must be publication of these, there must be reasons given.
But we'll never know, right? Because if they do settle with one party or one entity, at least in that consent order, we'll get the details of the allegations or the alleged violations. But if they choose not to settle with another party facing a similar charge or a similar default, we'll never really know on what grounds they chose not to settle, because they're not compelled to tell you, look, I chose not to settle on XYZ grounds.
And in fact, as
Menaka, that's where the general law, that's where the but which is where I feel the general law will come into play, that notwithstanding the fact that the consent application requires a waiver of rights of appeal and all those stuff, it would amount to, in a sense, if you are using discretion frivolously, unreasonably, Article 226 will be invoked, because judicial review cannot be stopped. It's a basic feature of our Constitution.
I get that. And in which case, what I want to tell you, or ask both of you then, is that under this vague wording of the regulations, if they, let's say, give somebody who is facing an insider trading, or a FUTP charge of some sort, the opportunity to consent or settle, they'll have to give everybody with the same kind of offence an opportunity to settle. Otherwise, you're going to face the outcome, as Shardul pointed out, which is that somebody's going to file a case against you in the High Court and say, hey, why did you leave me out in this process? So this just makes matters more confusing.
And I think while Sridhar correctly says that they can dismiss something in limine, there is enough case law to suggest that if there is an order which is unreasonable, even post-fact decisionally, you can ask for reasons.
So let me ask you both this follow-up question. would you be okay if they maintained the may not, but they also then made public the reasons for why they've accepted one case and rejected another in the same category of violations? Would that be okay with you? Or would you just prefer that they either revert back to shall not and let that be a hard black list, or that they just do away with this negative list altogether and put down a guiding principle saying based on the severity of the default or the violation, we can take a call not to consent, which was anyways their prior prerogative, starting 2007?
Well, I'd like to kind of address that a little more in principle, and moving away from the exact wording of may not and shall not. I think the principle, and I think as Mr. Shroff also very rightly kind of identified, the principle is that if you are having a set of regulations, then let them be self-contained and let them have as much clarity as they possibly can with minimal amount of discretion. Because when we see a situation where a particular regulator has wide amounts of discretion and there is a lot of lack of clarity or very nebulous kind of provisions in terms of what you can and cannot do, it invariably goes in cycles, where you will start exercising enormous amounts of discretion. You'll get hauled up for it by a court, and there will be a big kind of media blowout.
And then you start diluting your positions.
And then the door just shuts.
Yeah.
And then no consent orders will be passed because now they've been hauled up a couple of times.
I feel, because of the fact that the application has a waiver of the right to take further proceedings, whether in appeal, that context really came about from the expression shall not. Because if you are saying shall not, then it makes sense to have no right of appeal. But if you say may not, and then you bring in the discretionary bit, then discretion has to be tempered with justice. Discretion has to be used reasonably, and discretion therefore cannot be fettered with a waiver.
Are you okay if they keep the may not, let this be discretionary, but allow for the right to appeal, and also, as Sridhar pointed out, make sure that they make public the grounds on which they have consented or the grounds on which they have rejected? Is that the formulae that you prefer, or is shall not?
That's the most ideal formulation. Menka, that's the most ideal formulation. But knowing how public interest litigation and issues, tend to get very, very, very hot in some cases, I feel when they look at it with a sense of, the kind of problems that they've faced for consent, they probably revert back to shall not.